Over the stage for our wonderful speaker, Paul Blizzard. Paul is an associate with Berkskin and Parr LLP, and he is an expert who focuses on many aspects of intellectual property, including preparing IP strategies, patent drafting, licensing agreements, privacy agreements, and website terms and conditions. And he's an absolute expert when it comes to this topic. Paul, we are so lucky to have you here, and I request you to begin the session.
Sure. Thank you, Alina. Thank you, Wendy. Thank you, Hayden, for the introduction. As you mentioned, my name is Paul Blizzard. I'm an associate at Breskin and Parr. Breskin and Parr is an IP law firm. We deal with all aspects of patents, trademarks, copyright, and litigation. The firm was founded in 1965. We have over 75 professionals at the firm, and we are very friendly to early stage companies. So we work all the time with early stage startups and startups who are just in the midst of commercializing ideas. So really quickly, this is me. I went to Osgood in 2017 of Osgood Hall, and now I'm a Canadian and US patent agent and an LSO member. So today, what I'd really like to cover for you is, keeping this as interactive as possible. Just before I go too far into it, if anyone has questions, I think it would be reasonable just to either send them in the chat. I'm happy to kind of have this be a little bit more interactive and discussion, but I do have a few slides to get to, so we may have to move ahead if things get delayed. But today, what I'm going to do is talk about the different types of intellectual property. I'm going to talk about IP and the importance to your business, a little bit about what IP is and why it's important, and then I'm going to go through a little bit on what an IP strategy looks like. A late edition of some slides relating to IP funding programs, because there are several IP funding programs that are available from both the federal and the provincial governments. And anyways, we will get to those in a bit. So from a high level, these are the main areas of IP protection that you should be familiar with as you start your commercialization of and your work. So there are many different types. There are trademarks. Trademarks are type of protection that's available that protects brands. Copyright, as you can see, the C with a circle around it is a type of protection that's available for original works like art and music and movies, software. Patents are their own type of protection, which protects specifically inventions and innovations that you may come up with through research or through your own, ingenuity. There is another group of protection that's a little bit less well known, that is the industrial design. So an industrial design is a protection kind of a little bit like a patent, except instead of protecting an invention, what it does is it protects the aesthetic of something. So the shape, there's various ways that this has been implemented. Finally, trade secret protection is another important area that you should be concerned with, especially as a startup or an early stage company. Secrecy and confidentiality is one of your most important assets, because it's often the only protection that you'll have at the very beginning. So what is IP? What really is IP? So when we ask these questions, what we're saying really for someone who's commercializing a technology or commercializing, creating a company, is what do you do the best? So what is it that your customers, what is the reason your customers would choose you over your competitor? What's the delta? And how do you distinguish yourself from your competitors? So when we talk about a strategy for IP, really what IP, the best way to look at protection is to identify these answers to these questions that are important to the continued success of your business. So really quickly, the text is a little bit choppy here, but really you can see there are different, different phases of work in terms of commercialization, and as you go, there are different types of IP protection that exist to cover these different aspects. So I'll leave this in here. It's for your reference. I'm going to continue with patents. Patents are one of the most important types of protection, intellectual property protection. Um, and a patent right is the right to prevent others from making, using, or selling the patented invention. So whatever the subject of a particular patent application is, you're able to exclude people from doing that. Um, Patents cover functionality, so features and functions that exist that are inventive. And one of the main sort of rationales for the patent system is that you get a monopoly for 20 years from the date of filing in exchange for the disclosure of how your invention works. That's a really key part, is that when you write up your patent application, you have to give away the secret, basically. You have to explain to everyone how it works. So here, I'm not sure if people have seen a patent application before, but this is the front page of a US patent publication. And you can get a sense of really all the information that's here. So this is actually a patent application directed to a rollable display that is been filed by Apple. There's many different pieces of information on the front of the page, but it's important to note that a few things. One is that the patent applications usually have an originating application. In this case, this is an originating from a provisional application. There's information including the filing date and the application number. Patents also list one or more inventors who are identified as the people who conceived of the invention as it's claimed in that patent application. So when you think about a patent or a patent application, it's really important to think about what's in the claims. So there's two parts to a patent application that are important. There is the specification, which describes how an invention works, and there are the claims that are at the end that describe what is the protection that either the applicant is seeking or that has been granted by the patent office in the case of an issued patent. So in this case, we have an electronic device comprising a housing and a display coupled to the housing. So what's interesting here is this relates to this flexible rollable display. So there's a pixel array configured to display an image and a transparent protective layer that overlaps the pixel array. Continue going through the rest of the claim, I'm not going to read the whole thing out. It's not necessary, but basically, it describes this screen that is able to be rolled. That there's a rollable portion that can be rolled up as was shown. So patents. One of the interesting things with patents is that there's a process involved, and it can take a long time. So as I mentioned before, there are various phases. So when we work to file a patent application, the first part is we will discuss and define the invention and try to build an understanding. The next part usually that occurs is that there is a patentability search where one of the patent drafters or a student will do a patentability search to try to identify relevant prior art. The relevant prior art is a requirement for patents. So in order to find, in order to find a valid patent, what happens later on in examination is the examiner will review the requirements for a patent. There are a few, but the two of the main ones are that it has to be novel, which means that it can't have been disclosed anywhere else in the world, and it can't be obvious. Obvious is, a tricky legal concept, but basically the question is, would the invention have been obvious if you were to combine the features of other patent applications or other non-patent publications. So when we do the patentability search, we're looking for prior art. It's a way to inform the application that gets drafted here. And then what that does is sets the applicant up on their best possible footing when eventually the application gets examined. We usually see applications getting examined about 3 years after they're filed. So it does take some time. That's one thing to be aware of. There are ways to speed it up, but uh, at some point at the end of the examination, you can get to allowance. You don't always get to allowance. An allowance is basically an agreement with the examiner that you have met the requirements and that a patent will issue to you. So when we talk about filing a patent application, patents are jurisdictional. They protect they give you rights that are national in scope. So when you are pursuing patent protection, it's important to consider the jurisdictional questions that can include where are your target markets, where are you planning to sell, where are you planning to manufacture if there's a device, and also where's your competition, where are they based, where are, what are other interesting industry trends that you might want to follow. So that's part of it. There are some other details that we can that exist for changing the timing or the costs that are associated with patents. Patents can be quite expensive. It's important to note that, for example, for many patent applications, it costs between $30,000 to $50,000 in order to go from the initial initial state to the final issued patent. So there are some considerations. Oh, I have a question. Okay, when we see patent pending, does that count in court as its own patent? If there's another patent that is also submitted the patent after yours, or is it? Let me tackle the first question, the patent pending question. So as soon as you file a patent application, you are entitled to mark your product that is covered by that patent application as patent pending. And it's a good practice to do that in terms of providing notice. So a really important part about writing patent pending on something is it puts people on notice that if you have patent protection or that you've applied for patent protection in that case, that they should be aware of that and that they should not try to copy it. So that's one reason why you see patent pending as okay. The second question, if there's another product that has also submitted their patent after yours or is not valid because it is yet to come to fruition. So when you file a patent application, you get a priority date that's assigned to the filing. That priority date is very important because it effectively stops the prior art, which means that if someone subsequently files something that is relevant to the patentability of your application, it isn't citable because your filing comes first. So it's basically you get to stamp a date on the patent application, and then that's yours, and you have that filing date, and that's one of the reasons why early filing is very important. We have another question from Jennifer that asks, what stage of your business do you need a patent application? That's a very good question. The strategy can shift, but when you're starting, I'll just assume that a lot of the people here are early stage, because I don't think it is necessary to go into the case when I'm a lot larger and established. So patents, the best time to consider a patent application is when you are close to making a public disclosure of your invention. It's, as I can see on the slide, disclosures are important to patentability. Your own disclosures can form prior art. So that's a very important point. So if you are considering a public disclosure, if you're going to say, send your widget to a factory to get it made, or if you're going to release software on the internet for people to use, those things are considered to be disclosures. So, or let's say you're working at York and you are working in a lab and you want to write a paper or a publication that describes a particular method that you're using. Um, if you are planning an upcoming disclosure, that's the best time to file a patent application. Once you file a patent application, then your own disclosure, your own disclosure of the contents of the application is not a bar, but you can actually create prior art for yourself if you disclose something and then don't file a patent application. So idea protection is part of that. So it's important. Leela asks if ideas are protected as part of a patent application. You can't patent ideas, so you can patent. One of the main hurdles for patentability is that it has to be considered patentable subject matter. So you can't patent mathematical concepts. You can't patent laws of nature. There are many things that fall under the category of unpatentable subject matter. Ideas, you can't really patent an idea. What you can patent is the implementation of a solution to a problem. It may incorporate an idea in the use of some particular technology or something, but really the protection that's given is not for ideas. And Leela asks, why do some patent agencies recommend to apply for US patent and don't mention to apply for Canada patent in Canada and other countries? That's also a good question. The reality is the United States is a bigger market. It's the biggest market, and their USPTO is a great place to start. A lot of our best practice when we file patent applications is to file in the US first. We always do that. Well, almost always do that. We usually would file something called a US provisional application. After you file your originating application, you have a year to file other cases claiming priority back. So often, once you file the originating case, that's the time when you start needing to consider where else you want to go. So usually, I see clients who will file US provisionals. That will then be used to file other national filings in other markets. There's another process that you can use called the PCT, the Patent Cooperation Treaty, where you can file what's called an international application. There's no such thing as an international patent. There isn't such a thing, though, however, called an international patent application. Um, all right, I'm going to move on because you guys have lots of good questions, but I'm going to keep going. Sorry, I'll have to pause these for now. So in terms of what's required to have a valid patent, as I mentioned, your claims have to be new, which means the contents can't have been disclosed anywhere in the world, even by you. Disclosure of an invention can lead to a complete loss of patent rights, which is very important. So when I talk about disclosure, it's really important that applications are filed prior to that. There are some jurisdictions that have grace periods, including Canada and the US, but some jurisdictions don't, like Europe. So that is one main point on novelty. In terms of utility, like an application has to be useful. This is a concern mainly with pharmaceutical patents. Pharmaceutical patents have particular hurdles when it comes to utility. I won't go into that in much detail, but basically it has to work. It can't be a perpetual motion machine. The non-obvious hurdle is the same idea. It's similar to novelty, but really what it means is, can you take parts from different patent applications and put them together? Finally, for software especially, and for bio and some other types of patent applications, patentable subject matter can become an issue, which is to say, it has to be something that is a technology. It can't be an abstract idea or a conceptual thing. It has to actually, represent something that is tangible. So really quickly, I've included this for reference in the slides, but I talked about the different parts on the front page of the patent application, talked about the claims, talked about the description. I'll leave this in for your reference, but we've gone through a lot of this already. As I mentioned, the claims are the most important part of the patent application. There are a set of sentences that define the aspects that are protected, and they define the legal rights. So those are the reasons claims are very important. When so Colin asks, what keywords should I use when searching the patent database to check the unique elements of my video game? That's tricky, Colin. I think what I would do is I would go on Google Patents. I would search for parts that you think are the most innovative that you've created. You're not going to search for the whole game. I think that a good way to approach this, Colin, is to reach out to the IP Osgood Innovation Clinic. They're a good place to start for prior art searching. You can also hire someone else to do a search, but the IP Osgood Innovation Clinic does pro bono patent searching, so that might be a good solution. Hassan asks, do conceptual models get or should get patents? No, as I mentioned, abstract ideas, things like that are not patentable. So one particular area that I think is relevant to a lot of people and relevant to my own practice, is software patents. So software is considered patentable. The challenge with software is that you have to describe things that are technical improvements. For example, applications relating to security, encryption, compression, or relating to a user interface. You want to look for applications or cases that have integration with hardware. So if you have a sensor that you're integrating, that's one way to do it. Where there's a transformation of things from one state into another, and otherwise where there's unconventional components. This is viewable. You can see, looking at statistics on the number of granted US patents that are related to software between 1991 and 2019, you can see there's been a steady increase. In and around 2019, something like 60% of all patent applications were directed to software. And I would note, as we go through the remainder of the presentation, while patent protection can be challenging to get for computer software, there are also some alternatives that I'll mention, which include protection under copyright, protection under the industrial design regime, and trade secret protection. Finally, one area that I work in particularly that I think is particularly relevant and getting developed all the time is what is involved in patenting AI or drafting patent applications that are directed to AI and ML inventions. The way that we look at these is usually by breaking down the innovation and trying to identify where it's happening. Very rarely we will get foundational AI cases. These are, innovative ideas that relate to the underlying AI algorithms. Second, what we see a lot more is AI that's integrated into something or being used in some other system, where an AI or machine learning algorithm is being used sort of off the shelf and then used in an existing system. So that's another way that we look at it. Finally, some more challenging areas of protection include expert systems and classifiers. That's where predictions or decision making is being made. And there's a very interesting topic that I just spoke on relating to AI generated products, or other inventions related to AI inventors, but I'm not going to go into too much detail on that. So as I said, one of the key questions when we draft these applications is to identify where the innovation is, where's the invention. So often we'll draft claims for AI patent applications that are directed to the design of the model, how the training data is collected, processed, or stored, how the training engine addresses certain technical issues with respect to the model, and then finally how a trained model is used in order to make predictions or inferences. This is a summary slide. It goes through some of the challenges that you may encounter in terms of subject matter in different jurisdictions. I recommend, if you're interested in this, then to check it out and to reach out. But these generally cover some of the areas that may or may not be potentially patentable in this respect. So next, I'm going to talk about just wrapping up patents right now. We have one more question regarding the software patent. If we were developing an app that uses embedded technology by connecting to your Apple device, would that be one where patents could apply? So Tiona, it is certainly possible. The way that you'd want to look at specifically how you're doing what you're doing and what your innovation is. Obviously, you're not going to write a patent application to try to claim the Apple device itself. What you would look at is innovative aspects of your own implementation, and then you can connect them to, in the claims, connect them. But so okay, industrial designs. Industrial designs, as I mentioned,
Sorry, Paul.
go,
Sorry to
go ahead.
interrupt you. There's one more question, if you
Sure.
don't mind taking it. Sylvie is asking, if you sell a recipe to a distributor, do you file a patent or a copyright prior to submitting to them?
Thank you. I'm sorry I missed that one. So Sylvie, recipes are actually a very interesting challenge with when it comes to IP. Recipes specifically, if we talk about them in terms of the protection under copyright, copyright protects the expression. So if you have a book of recipes, that is absolutely protectable under copyright. However, the individual recipe that you would write that would result in, say, you're creating a cake, the cake recipe itself is to protect under copyright, because it's really, your protection would be limited to the content of the expression of the recipe itself as it's written. It doesn't protect, copyright also doesn't protect ideas. What it protects is the expression of change the recipe in a, in an insignificant way, but that change the expression of how the recipe applied. You may not be able to claim protection in that regard. It's very, copyright is thin when it comes to what is actually being in terms of the idea of, in this case, for the recipe. With patents could apply to a recipe, and the way that you would apply a patent to a recipe would be a method of manufacturing, or a method of making something. So the challenge is, with a recipe, I think you'd want to consult, if you're in a situation where you're considering disclosing it to a distributor, or that's something that you foresee. There are many ways that I would consider protecting that, but you'd want to probably talk to a lawyer, if because they can be challenging. Trade secret protection is another way to protect a recipe. If you could get the distributor to agree to sign a non-disclosure agreement, that would be one potential method. Or you could file a patent if it was a recipe that was novel. That's another way to approach it. There are many patents that are directed to methods of making food, for example, is one way that you could look at that. So industrial designs. Industrial designs cover the shape of things. It's kind of an interesting area, because they have a term of protection of up to 15 years. They don't protect the features or the utilitarian aspects of something, but they do protect the shape. So a really good one that helps to understand what it is that is actually being protected is, the Coke bottle. For a long time, Coke had a 2-liter pop bottle that was just its own distinct shape from the other 2-liter pop bottles. And that design is protected. That is a protected design, or it was. And in this case, what I have up on the screen is a registration, I think, for another type of pop bottle, but that has the same kind of curved shape applied to it. Um, designs designs protect other things too. So what's interesting is the Apple and Samsung case that was a big patent case in the US actually included many industrial designs in it as well. Those included the shape of the phone. They also have application to user interfaces. So the shape of the icons on the iOS home screen was a design patent. Um, so again, this is from an actual design case, and you can see the claims here. We claim the ornamental design for an electronic device substantially is shown and described. So the claims of a design are the drawings. Anything that is dashed is disclaimed, but the solid lines, for example, the iPhone here, those are the things that are part of the claim for an industrial design. So the next section I'm going to talk about are trademarks. Trademarks, trademarks are a very important type of protection, and they're maybe something that is, you know, a small factor at the beginning, but as you begin to commercialize your idea, but as you become more established, trademarks are very, very important. So trademarks can be a word, they can be an image, they can be but a trademark is used to distinguish the goods and services, your goods and services. The purpose of a trademark is that if you put it on your product, you put it on your website, you put it on a service you're providing, it uniquely identifies you. And that's what the protection is there for. So when you have a trademark, it is necessarily associated with particular goods and services. So that's an interesting point that you that I'll go through in a minute. But basically, while you may see a registered trademark for Popeyes for chicken for the restaurant, you will also sometimes see Popeyes for nutritional supplements, things like that occurring. That's a clear case where they're in two different fields and there's really no confusion about the chicken and nutritional supplements. So the content of the mark, as you can see, can be colors. So you can trademark color. You can trademark an animation, as you see the Google animation or the line at the bottom are both registered animations. They can be a slogan, so you're richer than you think. They can be a logo, or they can be a word, or a combination of those things. Important to note that that trademarks are different. For trademarks, how different does the name need to be to not infringe? The question with Peter asks the how different does a name need to be? The question with trademarks is whether they're confusingly similar to another good or service for which there is for which they're the same within the same set of groups of goods and services. So the ugly duck tea versus ugly duck tea would absolutely be confusing. Ugly duckling tea likely also confusing, but you would need to, you need to analyze. You need to consider that. Usually, with trademark cases, this is done by surveys of people, and they'll try to distinguish. For this mark, who do you believe it refers to? So. So returning to the slide, trademarks, they're different from trade names and they're different from company names. So a trade name identifies the named corporation, partnership, businesses, or individuals. So for example, Pharmaprix or Shoppers Drug Mart. A company name is the legal name registered federally, provincially, or territorially. So you'll see numbered companies or Shoppers Drug Mart Corporation. Those are the legal names that are registered with particular federal or provincial agencies. The trademarks identify products or services that are sold by a company. So in the Shoppers Drug Mart example, you have Life Brand, which is their house brand, or the logo for Life Brand, which is an actual a trademark. Now, what's important to note with trademarks is that there are, first of all, as I mentioned, it protects your goodwill, the goodwill of your organization, your company, in association with a product or service. So as you become more established, the quality of your products is something that people associate with your name. So that's important. And you have to, the reason why trademarks exist is to protect people from counterfeit products that are applied using the same, the same trademark that identifies where it comes from. The one other important thing is that trademark rights can exist at common law. These are called unregistered marks. So when you see a mark that has a TM applied next to it, that's an example of an unregistered trademark. Those rights can accrue just by use of the mark on the products or services that they may be associated with. There's also a scheme for the registration of trademarks. That's the R symbol with the circle around it. A registered trademark has many benefits. However, the registration is a user to lose it type of situation. So if you continue to use the mark in association with your goods or services, you're okay, but you can have your mark expunged if you don't. Registration is a process. It kind of works a little bit like yeah, a little bit like the patent prosecution, but basically you file a trademark application and you list the goods and services that they're associated with, and then through an examination process you can receive a registered trademark. And what's interesting with trademarks is that there is no expiration, provided that you continue to use the mark and that it is distinctive. There are some ways that you can lose your trademark rights on the basis of your word, the term that you're using not being distinctive. I'd point out something like Kleenex. So Kleenex is a good example of something that has become a generic mark where people don't refer to tissues or facial tissues anymore. They refer to Kleenex. So there are some ways that you can lose it, but again, the protection, I mean, registered. Good question. So a registered trademark, the benefits of having a registered trademark are mainly that they are registered across an entire geography. So when you register a trademark in Canada, the rights for the registration extend across all the provinces. And when you talk about common law rights are generally within a particular local geography. You may see, you know, a prior user who has common trademark, or like a restaurant is a good example. A lot of restaurants don't register their, like single restaurant is not going to register its trademark because for them, the protection, if they're in Toronto, they need protection in Toronto. They don't necessarily need to have, protection across the entire country. But that's really the biggest the biggest benefit is that the notice extends across the entire country, and then having that registration also prevents local users of the mark. Thanks, Sarah. That's a good question. In terms of choosing the right trademark, so obviously, if you're at an early stage, the name that you pick for your product or service is important. I'd recommend thinking about very carefully what it is you're going to call your product. Now, as we are showing on this graph, the vertical axis is strength of the trademark. Horizontally, we're looking at the relationship to the existing goods and services. So as for trademarks that are considered fanciful, so coined terms, words like Xerox don't, for example, don't exist in other language, like in any language. In English, there's Xerox doesn't mean anything. It isn't a meaningful term. It's something that's been created as a word to use in association with only Xerox products. That's an important one. Dictionary and arbitrary terms. The the use of a dictionary term that is not really connected, and basically an arbitrary association of Oracle with computer software, that's that arbitrary association. And so that is sort of the next step down in terms of trademark strength. Um, as you see, a lot of trademarks are actually suggestive of the products or services that are being provided. So Netflix is a portmanteau, network and Flix. So we're looking at something that starts to describe what it is. And so obviously not the strongest of trademarks. And then finally, there are some descriptive marks that are used. For example, sharp for televisions is one. Clearly, the image is sharp. That's a descriptive term that describes the product. It is a sharp TV. And so finally, words that are generic. So for example, beef for beef would not be registrable. You could not use terms that are plainly descriptive of the product or service in order to identify that as your product and hope to achieve any rights in terms of trademarks. There's some other things that can't be registered. So in terms of what actually can be registered, so you can't register trademarks that are primarily a name or a surname. You can't register marks that are descriptive, so clearly descriptive, as I mentioned, beef, or deceptively misdescriptive marks. So if you try to register a trademark beef for pork or beef for chicken, that's a deceptively misdescriptive mark and thus is not allowed to be registered. Trademarks that refer to geographic locations are also similarly problematic. Foreign language terms that describe the good or service, for example, like using a translation of the word from another language, the good or service from another language. Another thing that cannot be registered, as I mentioned, is words and designs that are confusingly similar to another registered trademark or pending trademark, and words or designs that are simulated to a prohibited mark. So there are some prohibited marks. There's also an important note that some government agencies, for instance, like OLG, have what are called basically they have their own marks that are in the register, and for sometimes you'll encounter these marks that are sort of generally applicable across any good or service. That's one benefit of being the government, is you get to make your own marks. So so when we work with startups and we talk about brand protection and trademark protection, it's important to, so I use some examples. So Peter asks, with the same example, if I use ugly duck tea is a tea shop that I'm looking to sell teas online, would ugly duckling teas be different enough or no? No, probably not. The question is always, if you're selling the same products and if your if the name that you're using is very close in terms of the words that are being used, if you're adding a suffix on the word, it's often not going to be. It depends on the prior owner rights. Like if Ugly Duck Tea is a registered mark, if Ugly Duck Tea is a tea shop that is a single tea shop that is on the other side of the country, then you're probably not going to have an issue. But if it's registered, anyways, uh, it has to be your whatever you're doing has to be sufficiently clearly different in terms of the name. You can't really pick words that are very close to other names. That's why clearance is important. So second point, um, identify the trademark that you're going to use. Second point is conduct a clearance search to see if someone else is already using it or if it's already been registered. So there's kind of two sides to it. One is whether it's a registered, it's in the patent, sorry, it's in the trademark database. And the other question is whether there are senior users who have the mark for their restaurant or some other use that is not registered. We often will work with clients to register the trademark by filing trademark applications. And then from there, what happens with trademarks once you have them issued is you'd start sending notice letters to people who have names that are very familiar or very similar or confusingly similar in order to enforce the strength of your own mark. One of the key parts to a trademark is if you're going to pursue trademark protection, you definitely have to be ready to protect it and to send letters, because it's up to you to make sure that you protect the use and the of your trademark against others who might try to use it. So really quickly, if you're starting out and you want to try to clear trademarks on your own, what you should do is search prior to using it, prior to registering it. Do some searching. Look on Google. Look on the trademark the Canadian Intellectual Property Office and the U.S. Patent and Trademark Office have publicly searchable databases that you can go to. You can look in the register. You can also work with a firm. I recommend it's a very good idea to work with a firm to get a knockout search. There are some more comprehensive searches that can be undertaken in order to look for use of marks that might be similar, that is, just common law use, either use in the market or, use by existing actors that haven't themselves registered the mark. Another thing to be concerned about is sound-alike marks, so things that sound the same but may not be spelled exactly the same. And anyways, this type of searching is something that we work on. Also, the IP Osgood Innovation Clinic is a good first stop if you're just starting out. They do trademark knockout searches too. So I recommend reaching out to Hayden or to the clinic. And one important note for you as you move ahead, you definitely want to use your trademarks properly. You want to avoid generic use. So your product name is not a noun or a verb. Innovation Clinic. Oops, I sent that directly. Anyways, when you use your trademark, it is an adjective. It's an adjective followed by a common name. So to take the Kleenex example, it is a Kleenex facial tissue. It is an adjective that describes a noun. That's very important, and it's very important that you consider using it as an adjective. The other thing to do is it's important to distinguish the trademark that if you want to use a word as a mark, you need to distinguish it. So you can bold it in agreements, you can bold it on pages or websites. You want to use the mark consistently based on the way that you envision it, like really just hammer on making it the same. And also, finally, you want to put people on notice that you have rights, or that you believe that you have rights associated with it. For unregistered marks, use the TM symbol, and for registered marks that are active, you can add the registered trademark sign. Any questions on trademarks? Okay. So moving ahead, do you think that your interested could benefit from trademarks? That's a good question. I mean, uh, let me think about that one for. I mean, everyone can benefit from trademarks. I think due to the association, the word, I don't know, like, uh, if you're concerned about someone free riding on your goodwill associated with the name of Y space, for example, then that could be a thing to register. I think that you need to think about, what your needs are in order to do that. But that's an interesting question. Um, I what would you register it under? I suppose I'm not sure. The trade secret protection is probably one of the most important things that I would um, put out to you as early stage. It's a tricky question. So thanks, Coco. Um, the trade secret protection is something that is very important in early stage companies. This is because you may not have the means to file for a patent application. You may not have crystallized the idea sufficiently to write a patent application. You may be just iterating on an idea, and it may go in any number of different directions. So when you start out, confidentiality is very important. So the regime for trade secrets provides protection as long as information is kept secret. And you have to take steps to protect the confidential nature of whatever it is that you're trying to keep secret. That includes control and physical barriers. So if the earlier example with the recipe, as an example, having a good non-disclosure agreement in place signed with any third parties that you're working with would be a really good idea. Like that's a really important idea, just to make sure that there's an understanding that what you're giving them and that that is the subject matter of your relationship with them is highly confidential, and that there's consequences if they breach the confidentiality. Another way to do this is to limit the knowledge to people who need to know, and obviously keep the information confidential. Don't disclose it to people. So as I mentioned, trade secrets are usually the way that protection works at the early development of an invention. Um, there are many ways that you would want to do that. As I mentioned, non-disclosure agreements. Another big vulnerability to early stage companies is you would want to put something like that in an employment agreement to try to make sure that there's an obligation of confidentiality for anyone who you've hired or who is a partner in the initiation of the commercialization. Um, so we have another question. Rose asks, what's the cost of registering trademarks? I think the cost that I recall seeing the last time, it's about $2,000 to $3,000 to do the registration. And it goes through, it's a lot less than a patent. So that much is for sure. You do have to pay maintenance fees on a regular schedule. So that's one thing, is that if you register a whole bunch of trademarks, you're going to have to both use them and pay for them forever. So just I think about that in terms of what you want to do strategically. The other way, getting back to this question, is when a trade secret is a good idea. It's also a very good idea to consider uh, trade secret protection when something is impossible to reverse engineer or very difficult to reverse engineer. So a good example of this is the recipe for Coca-Cola or the recipe for Dr. Pepper. The recipe in that case, you could have many steps. The manufacturing or the creation of the drink or the beverage may have some things that would be very difficult to reverse engineer having the product. So some products like Coca-Cola, you can look at it, you can use a, gas chromatograph or whatever, get an idea of like what is the composition of the different molecules or the things that are inside the drink, but it may not provide you any information about how it was made in a commercially viable way. So in situations like that, trade secret protection is actually very viable, but your situation may vary. So that's one of those times you want to consider talking to a lawyer and reaching out and trying to identify, how to best protect yourself uh, if you're releasing a product that you want to keep trade secret. There are some products that you can reverse engineer. So mechanical inventions, like let's say you built a mop or or a broom or something that was innovative that worked in a particular mechanical way. Um, all someone would need to do is buy a product and cut it in half, and they would be able to figure out how it works. That's like a very real consequence of selling products, is that you're going to sell your product. Someone is going to want to know how it works, and they're going to go and take a buzzsaw to it to try to see how it works inside. So that's just the nature of products and reverse engineering. So there are some risks to relying on trade secret protection. First and foremost, if the secret is disclosed publicly, whether it's accidental or not, you can lose your protection. So it is only viable as long as it is kept secret. If it is not a secret anymore, then you do not have protection. So that's one main risk. Um, the other, as I mentioned, employees pose a particular risk. One way that that happens is that there's a kind of a threshold question about how much are you able to claim is yours and how much is simply the employee's know-how and their ability to be a professional in a particular area. As I mentioned, products that can be reverse engineered, you're likely not going to be able to rely on trade secret protection on them. Another thing that trade secret protection doesn't give you any protection from is independent discovery. So if someone independently comes up with a recipe for Coke without, stealing it from Coca-Cola, then there's not an independent way to recover in that case. Another challenge with trade secrets is if someone else files a patent application, you can't say, "Oh, look at this prior art that might invalidate that." Uh, so again, patents. I think the best way to think about patents and trade secrets is like two sides of the same coin. You kind of want to balance them both. You want to keep things secret until you've crystallized that idea, and then if you're planning to disclose the idea, that's the time to file a patent application, or when it's crystallized sufficiently that you can proceed with a patent or an industrial design. Those are the times that to think about that. Just keep in mind, if you're planning to disclose publicly or tell it to a third party, anything like that, then that's the time. So, oops. And as I mentioned, it's a really good idea to get a hold of a good non-disclosure agreement or confidentiality agreement. If you reach out to the firm, or if you reach out to, I don't know if IPL is good, does that, but a good NDA agreement can help you in many ways in that respect. I would also mention that with trade secret protection, the way that trade secret protection is generally formed is through contracts. So you would have a non-disclosure agreement that would protect you from the other party disclosing the information. You would have a confidentiality agreement and an employment agreement, which would prevent your employee from disclosing. And there are some limits to the recovery there. So there are some challenges with using trade secret protection for those reasons. Okay, so copyright. Copyright is another interesting type of IP protection. Copyright protects works that are expressed. That means they have some tangible or basically that are not the idea itself. So an expression of a book or a song, copyright, the standard under patent law for to have a viable patent is novelty and non-obviousness, but kind of the analogous standard for copyright is originality, which is to say copyright doesn't extend to things that are not. There's a minimum threshold of originality that's required in order for copyright protection to attach. Also, copyright, the copyright work needs to be fixed in some way. Fixed means that it is printed on a paper or it's stored in the memory of a computer, things like that. There's many different types of works that copyright covers. Literary works, software is covered as a literary work. Artistic works, musical works, dramatic works, compilations. In most cases, copyright is automatic. It applies as when the work is created, and it attaches at that time. The registration for copyright also exists, but it is not mandatory. It depends on different countries have different rules, so I recommend if you're interested in copyright registration, talk to a lawyer. So another good way to cover your bases is to add a copyright notice. For example, if you're creating a website, in the footer of the website, adding the copyright sign, the name of the owner, the year of the publication, and that's one easy way to put people on notice that you consider the thing that you're writing that on to be a copyright protected work. So we have a question from Rose. Copyright in songs. When we publish our original songs on YouTube or other social media, does that mean that we automatically have the copyright to it? That's a very interesting question. So I recommend, if you want to have a snooze, go and read the terms of service and the privacy policies associated with YouTube. Therein you therein you will find that you grant a worldwide. Generally, you grant a worldwide non-exclusive license to YouTube to use it. But you'd likely still be the owner of the work, but you'd have to check the terms of use. So if you're creating works on another platform, I don't think usually they'll include a licenses, and one thing to note, here you go. So authorship and ownership with copyright are different. It's kind of similar to with patents. So the author of a work is the first owner. So if you author a work, you are its owner. However, if you create a work in an employment relationship when you are an employee of another, works that are created in the course of employment belong to your employer. That is one of the underlying assumptions of the Copyright Act. However, if your startup, let's say you hire a contractor or a freelancer to do your logo, it's important to note that you should get an assignment, because if you're in a contract-based relationship, like it's kind of the same issue as with Uber drivers, they're considered independent contractors. If you have an independent contractor who creates a work, they're the first owner. So what you need to do to cover your basis is make sure that you get an assignment. So a license is something that gives someone permission to use the work, but you retain the ownership. An assignment is basically you giving the work and the rights to the property and the work to that other person. Just to clarify that. I have some questions here from Sylvie. Can you put the R symbol even if the application isn't submitted? No, do not do that. That is a bad idea. There are consequences, legal consequences for identifying something as a registered trademark if it is not. Don't do that. If you want, use the TM symbol. As soon as it's filed, then you use the TM symbol, and then later on, subsequently, when you have the trademark issued, then you can use the R symbol. But you can't use the R symbol if you don't have a registered mark. So Next question from Colin. Does the development of a video game automatically qualify for copyright protection? And if so, does this make my game a viable candidate for IP-based funding opportunities? Good question. What I would say, the source code, so the source code that you write for your game is absolutely, unless it's something that is purely mechanical in nature, like if you were, writing out something that didn't really have much of an expression in it. Source code is protected as a literary work, so when we talk about protection under copyright, it's really protecting software code as a book. That's kind of the idea. It can also, protect images or songs that are being created in terms of your game. It would apply to the writing of a video game. The source code that's associated with that is absolutely protectable under copyright. One thing I would mention, the copyright notice, the C symbol and your corporate name, you should put that in the header of the, in comments in the source code files. That's one way to put people on notice. Sylvie, how does copyright work with blogs? Copyright extends to blogs the same way. It's an expression. It would be considered a literary work as well, and you'd have protection as well. How do you file a trademark? I recommend go on the CIPO website, the Canadian Intellectual Property Office website, and they have some instructions there. You can also reach out to a trademark agent. You can find those through the College of Patent and Trademark Agent websites if you search there. Do you put the C symbol even if you have not registered for copyright? The C symbol is fair game. You don't need to register your copyright to put the C symbol. Can you touch on the assignment part again, especially around contractors, from Sarah? So one important thing is if you are using independent contractors, so freelancers, contractors, consultants, people who are not considered employees there's like a legal scheme that kind of separates people into employees and independent contractors. The creation of works by those people may require, it would be a best practice to get an assignment of those rights to you at the end. Another thing that's important to note is that it gets overlooked because Canada has a slightly different, an assignment is a contract, so you'd have to have a nominal contract. I'd recommend getting a lawyer to write it. There's a nominal contract for an assignment that would involve like a $1 contract to have the rights assigned from the independent contractor to you as the person who hired them. Another important part that you want to look for, both in your employee agreements and in your and in assignment agreements, for example, is you want to get what's called a moral rights waiver. So Canada has a scheme that's similar to the European copyright concept. I The best way to describe it is that if you're a creator of a work, there are some other rights that cannot be assigned that need to be waived, and those are the rights to the prejudicial use of the work that you create. But if you have a concern, what I recommend is, contacting a lawyer and having them evaluate the specifics that you need in order to ensure that you have an assignment, and as well that you have moral rights waivers that can cover the creation of any works that you might have your employees or independent contractors doing. So I've included this for reference. This is a really quick slide that goes through some of the different schemes that we've talked about. I think it's important to review, but I'm not going to go through each part. It's kind of just a summary of what we talked about. I also wanted to touch really quickly on IP agreements and licensing. This kind of goes along with what we were just talking about. So one of the keys, I think, is to consider your relationships with others in view of IP. That includes contractors, employees, partners. Who owns the IP in those relationships? A good example of this would be if you were working on a joint development with someone else or another company. Joint development can be very thorny in terms of the ownership of IP that's generated. And I highly recommend getting a lawyer in that case. You really want to look at the most important concern is what's the IP, what's in the background for each of the parties, and uh, what is the subject matter of the agreement and who owns what gets created. So I talked really quickly about licenses. There's three forms of licenses. There are non-exclusive licenses that apply that you would basically you can license any number of licensees with the for the same thing. There are what are called sole licenses, which is that you maintain a license and you grant only one other licensee the right to use. An exclusive license, you would grant all the rights to the work to somebody else, and you in that case you don't retain the right uh, to use that. I'm going to skip over the next part. I have a part on open source licensing, and it's really particular to software, but it's in there in the notes. And if you have specific questions, then feel free to reach out. Finally, it's really important to consider the collection and use of personal information. PIPEDA is the governing statutory authority. The main thing there's a couple of main things, but really, if you're collecting personal information, it's important to consider whether you have consent from the person you're collecting that information from, and you have to make sure that you have safeguards in place in order to protect that personal information, having collected it. I recommend the Privacy Commissioner. Their website has a lot of good resources that that can help you. And if you're collecting significant amounts of personal information, I highly recommend getting a privacy lawyer involved in order to advise you on the proper way to get consent, the proper way to store and safeguard that information, and to really get a sense of what the risks are in collecting that information. So really quickly, safeguards can include up-to-date technological tools. That includes passwords, encryption, firewalls, etc. But also a lot of the challenges as they pertain to software as they pertain to personal information is that you need to have organizational controls in place to limit access to people so that people can't just go and look through a whole sensitive information that you might be storing. Really, again, really hammering home the note on meaningful consent. You have to this is what a privacy policy provides, is generally when you agree to those agreements, when you're signing up for Facebook or whatever, there's always a giant agreement relating to the use of your personal information. And it can be more challenging in terms of the way that you're communicating with your users about meaningful consent. So you have to really help people understand what you're doing with it, and make sure that they understand what they're doing what you're doing with it when you collect that data. Question from Leila: if I applied for a utility patent for the project as a founder of a new startup company and then collaborate with investor and university, what is ownership contribution for my company, investor, and the universe? It's a very challenging hypothetical. In you know, the having the patent rights beforehand, if you're talking about a situation where you are working on something yourself first, alone, without anyone else's help, then it would be a very good idea to apply for a patent prior to collaborating with others, because you would have a residual right to whatever. If the IP that would give you something, you would need to be really clear with your collaborations with your investors and university, etc., what that, whether and what your background IP is, and you would want to be clear that you're not assigning anything to them or granting any rights. In a situation like that, you should get a lawyer. There's only so much I can tell you in this kind of environment, but basically, like in that kind of a situation, if you're concerned about the use of your IP by an investor or the university, filing a patent yourself ahead of time is a good step. Filing a patent or getting advice from an IP lawyer is a very good idea as well. And I think that you'd want to consider all of the facts, like in whatever particular situation is there. It's difficult to answer that question in the abstract. So yeah, and I think I recommend a couple of things, like if you're creating a website, things like that. Privacy policies and website terms of use are very important. Please reach out if you have questions or needs with preparing those. People often will look for them on the internet just to use, but often those things uh, you know, won't cater to all the needs that you may have. So really quickly, returning to what we talked about at the beginning, IP is only one part of a successful strategy. Sometimes people get hung up with IP as the strategy, and sometimes IP is the strategy. It is to get a really powerful portfolio of IP and then license it. That's a totally viable thing. What IP allows you to do is to take your concepts, your innovative ideas, and to turn them into things that you can exploit. The reason why IP is beneficial, and the reason why having a strategic approach to IP is beneficial, is that you can use the assets. So in some cases, IP is the only thing that some companies have, whether it's a trademark, whether it's a recipe that gets licensed, or some asset that gets licensed out. IP can also be very powerful when you are engaging with investors. Some investors care about patents, some investors don't. But that is something that you'll have to sort of identify whether and which investors are interested, and what you may need in order to get ahead when you're talking to investors, or to get success. Um, from the trademark side, protecting the goodwill in your company name is very important. As soon as you start seeing commercial success, there's a very good chance that you'll start seeing people trying to free ride on the name. So it's a very good idea to register your trademark. And also, the IP itself can help you commercialize the technology and license out the technology. And again, I think in any conversation with an IP professional or an IP lawyer, what you really want to do is identify what's the purpose, the business purpose of the IP that you're getting. Obviously, for early stage companies, your budgets may not be huge, and you want to make sure that that the funding that you're using towards IP is reflective of your business needs, whether that's investment, whether you are pursuing a licensing strategy to license out your materials, whether you want to sell. A lot of software companies, for example, they want to build something up, have a portfolio of applications, and then exit within 5 or 10 years. That's a completely viable strategy with IP. But as I mentioned, IP really, you want to drive and maintain the competitive advantage that you have, and use the IP to keep people from copying the thing that you use to remain competitive. So yeah, and it's also important. IP is always forward. Patents, anyways, are always forward looking. There's a lot as well that you want to identify when you approach your IP strategy. Uh, what are your competitors doing? What's the technology doing? And what's your business doing? So So really quickly, I want to talk about some funding opportunities for IP. Uh, the landscape has shifted in the past 2 years in Canada. There has been a significant change in public funding of IP. A lot of the funding is available for free filing activities. So one of the biggest programs, I'll talk about it in a second, really focused on IP education. So if you are in an early stage company, uh, there are many programs that are available that can get you, a really good opportunity to get um, time with IP professionals to help teach you about different aspects, kind of like this, but more, driven by your particular situation. The other thing that a lot of the funding is available for is for the development of an IP strategy. Um, there are some limitations to the funding though. So the three main ones, I sent info sheets to Alina. So there are three main government programs right now. Two of them are federal. That's the IP Assist program by the IRAP. There is the Elevate IP program, which is separate from that. And finally, in Ontario, there is an organization called IPON, or Intellectual Property Ontario, that all of which are accepting applications, and you can use multiple you can apply for, you can't double dip, like you can't cover the same work with different funding sources, but you can participate in one and have a strategy report created under IRAP IP Assist, and then use the strategy report as a launching board in order to try to prepare other work or actions to be taken under Elevate. They're I highly recommend them. I do a lot of work with IP Assist right now. I have some work with Elevate, and they can be very helpful. So IP Assist is provided by NRC. That's one of the Canadian government programs. The way that to be eligible for IRAP, you need to get into the IRAP program. They have some individual requirements, including you need to be incorporated in Canada, you need to have fewer than 500 employees, and I believe you actually have to have at least one full-time employee, and that you're aiming to grow through innovation. So uh, the IP Assist program, it really focuses on education at the beginning, and then the development of a strategy program in the middle. And you will work with, in fact, if you'd like to work with me, you can ask them to refer you to me. If you work with an IP service provider, and can learn about IP, and you can also proceed with the other phases. So the one caveat with IP Assist is that it does not cover trademark and patent application drafting or filing costs or prosecution costs. It also does not cover FTOs. So that's a detail, but probably won't be that helpful here. But it's just to note that there are some things that they won't pay you for. And there is sort of an assessment process that will take place where you give a proposal, they will approve it, and then you can move ahead with the program. And part of this is you have to get into IRAP itself. So IRAP has a set of portfolio companies, and you have to get accepted as a portfolio company. When that happens, you get assigned an ITA, which is an industrial technology advisor. They are kind of like mentors who are industry advisors who have been there and kind of know where you're going. So uh, there's 3 levels, as I mentioned. I'll leave these in for your reference, but basically you proceed with level 1, you get a session that is very much like this session. Level 2 is up to about 20K, and then after that, you can get an engagement for level 3 to actually take care of the strategy that you develop in the level 2 engagement. IPON, there is a government agency called IPON that provides IP services. What you can do is you would need to apply. I recommend checking out their website. You need to have fewer than 500 employees. You need to grow the business in Ontario, and you need, you want to be targeting IP rights with an intent to commercialize. Um, so the three offerings I think that are important from IPON are an IP bootcamp. They have a partner program, and then they have a self-guided program. A lot of this is again focused on IP education, which I think is very important. Definitely more in depth than this, but it's a good opportunity to sign up. They're currently accepting and reviewing applications on a rolling basis for 1 and 2. And finally, Elevate IP is another program that's federal that provides IP support for a variety of different providers, or different companies, sorry. You you work together to build an IP strategy, and Elevate is more flexible in terms of what it will cover. They will cover prosecution costs. They do cover the drafting of patent applications. So it is another opportunity. Right now, I think it's being administered through these regional business accelerators and incubators. So in Ontario, we have Communitech and Invest Ottawa. And this was just recently launched. So if you're located elsewhere in Canada, there are other funding sources or other BAIs that are available. You'll just have to look up which ones. I think in the Atlantic provinces, it's Springboard Atlantic, and I think that I don't recall the ones that are on the West Coast. So Elevate IP, and yeah. This includes, again, IP awareness, IP strategy development, and then an implementation of IP strategies. And yeah, so if you're going through those programs, you're welcome to indicate that you'd like to work with us. So I'm happy to do that. I work with those programs all the time. And I think, Alina, are we at time?
We have enough 30 minutes.
Oh, okay. Well, I'll keep going then. So I have a couple case studies that I include in these presentations, and the first one, it kind of considers for some different organizations how IP has affected how they've approached IP, and how it has really kind of like factored into their business the commercialization strategy. So the first one is GoPro, and and GoPro was founded in 2002 by someone named Nick Woodman, and he is a surfer, a skier. He liked to do lots of outdoor stuff. And at the time, there was a lot of competitors in this space. Like cameras have been around forever. There was a lot of action cameras that were available uh, at the low end that were very cheap. There were also, these same cameras also have competitors that are in the very high end range. So like digital SLRs or SLR cameras, those Nikon and Camera all make very high quality cameras that can generally do, kind of the same thing. So you can see the pricing structure that was used for GoPro cameras, which was kind of in the middle, higher than the low end, and some overlap with some of the SLR pricing. Uh, but what was interesting with GoPro, because even though their technology wasn't super innovative, they did at the time they did pursue uh, um, a very interesting IP strategy. So, as I mentioned, 2001, 2002, GoPro was founded. There was a 35 millimeter Hero camera. 2004, 2006, there was the digital Hero camera. And then you've kind of seen the increase around the time when their HD version became available in 2010. And then their revenue went up very significantly. And they've added other products in the same time, including drones. They have a lot of other uh, uh, a lot of other things that they've included. But a lot of what GoPro provided wasn't really the camera wasn't really the innovation. What was really the innovation was the fact that you could attach it to a helmet and that it was waterproof. So so anyways, the this is a challenge obviously for patents because when the camera technology it's a camera, like it's just a camera in another box, and from a novelty or obviousness perspective, um, it's like, how do you protect something that is well known like that? So this is a graph that looks at uh, how they approached patents for these technologies. So uh, we have on the left, we have some of the earlier patents that were the 6955484, which is directed to mounting accessories. There are others here that are directed to more image processing. That's what happened later on. So you can see at the early stages, a lot of the patents were not actually directed to camera stuff. They were directed to mounting accessories. Um, and as time progressed, the patent strategy changed, and you can see a much broader set of patent applications that have been filed. They went from really only a couple a year between 2000 and 2010. And then starting around 2011, there was a significant increase in the number of patent applications that were filed. There was a lot directed to image processing. There was a lot directed to audio capture. There was all over the place. They were filing patent applications on all the different things. And so what's interesting is that these patents came later on, and a lot of it was related to, I think, the development of the HD or the HD version of their technology. So just to give you a sense of how that works. So this is pretty typical with patents, and what you'll see with patents is that at an early stage, you may only have one or two kind of cornerstone patent applications that are being worked on, and then when companies start to see commercial success or a significant increase in their R&D budget, then you'll start seeing significant amounts of patent filing activity. And as of recently, you can see only a little bit of their portfolio is actually directed to cameras. There are patents that are directed to all sorts of other things like drones, networking, multimedia editing, audio capture. It's not just the camera. And this is reflective of a lot of different companies. Like you'll see patents are filed, uh, for machine learning is a good example. Like the model itself may only be part of the innovation. There may be lots of innovation directed to how training data is created or prepared. So, uh, and what GoPro had really was a big first mover advantage, and that is that they had the action camera and they had really strong trademark association, trademark rights for the GoPro name. Like it's a very, very strong and well-known trademark. And they really created a kind of a category for them themselves. So anyways, a lot of their early IP work was enforcing trademarks. Later on, they increased the number of patents that they were creating. Um, and it's just an interesting example to see how how their late patent push worked, how a lot of the fact that a lot of the patent applications were for things that you wouldn't associate necessarily, like they would be for the mounting hardware, they would be for the waterproof enclosure, they would be for other things that weren't directly related to the cameras themselves. Another interesting case study was Nest thermostat. So uh, here again, we're talking about a company that started with a single product. That was the thermostat, the Nest Learning thermostat, which was a Wi-Fi enabled thermostat that has optimizations for heating and cooling. It was web enabled, so you could use an app on your phone to adjust the temperature. And it also included some machine learning features to try to regulate the thermostat and decrease costs. Um, they actually had to deal with a patent infringement lawsuit at the early stages. They kind of learned a lesson in 2012. There was an introduction also later on of other products, so they broadened their portfolio to include Nest Protect, which is a smoke and carbon monoxide detector. And then in 2014, Nest was purchased by Google. And so this is a relevant like product development or product release anyways. They've also developed a camera. You can kind of see them broadening their portfolio of products. But when you look at the patent portfolio and the filings from Nest, there are some interesting things to note. That is that there was a significant number of utility patent filings in 2008. There's a lower number that were acquired. These two groups, I think 2008 were acquired by Nest, so they bought them. They purchased a portfolio, and then in 2010, a set of patent applications. They purchased again a set of licensed patents from Intellectual Ventures, which is a non-practicing entity, which is also known as a patent troll. So they purchased a portfolio at the early stage to build up the number of patent applications that they had from a patent troll. So this was a different strategy where they acquired their own in addition to filing their own. And so you can see like 2011, there was a big focus on design patents, those related to the user interface and a lot of the shape of the device and the user interface of the device and how it looked. And then over time, they've really increased their utility patent filings. As I mentioned, they did a lot of work licensing and acquiring patents. These portfolios had early priority dates, so they were able to build a stake in a patent portfolio themselves without actually writing it. And there's a kind of a description of the different areas that the patents were directed to. So you can see Nest, by virtue of its the fact that it's a commercial product, they had a very serious approach to patents, and they still do. They have a lot of cases that they've licensed in that have early priority dates, and they've also built their own portfolio as well. But they're one of the main strategies they undertook was not only developing their own IP, but also licensing in from others. So, and that's it. That's all I have for now. If you have any questions, I'm happy to answer them.
Amazing. Thanks, Paul. All right, we're going to open the room for questions. Feel free to drop them in the chat or just unmute yourself and ask away. Honestly, I think there's so much information. Everybody's just mulling over all the insights that you shared. So thank you so much for that. I particularly enjoyed the case studies at the end because it tied so well with what all you had discussed theoretically, like just to see the product development compared to the patent portfolio as well. So I thought that was incredible. So yeah, thank you so much.